The rules around what you can talk about with people, the rules around what you can have them sign, and the money you can have them pay are all very much controlled by this regulatory scheme at the federal and the state level. And for emerging brands, it's very easy to make a mistake if you're not getting the right legal advice.
Welcome to the Franchise Scale-Up Show, the go-to playbook for founders racing from 10 to 100 units. I'm Guy Coffey, franchisor, franchisee, and growth advisor. I know firsthand how fast this game moves and how quickly chaos can creep in. That's why each episode gives you the clarity, systems, and hard-won lessons you need to scale smart, protect your equity, and stay in control. You've got the vision. I'll help you build the infrastructure to match it. Let's dive in. Hello and welcome back to the show. Today I have a special guest, Mr. Kevin Hein from the Akerman Law Firm. Kevin is the co-chair of the franchise and licensing sector team at Akerman. Akerman has 800 lawyers across the country. And what we're going to be doing is a short series of things that are particular to emerging brands. So if you are in that sector, this would be a great series for you to check into. So Kevin, welcome to the show.
Thanks, Dee. It's great to be here.
Well, I'm excited to go through this and provide value to the listeners because legal is involved in every aspect of franchising, as you know, from the beginning. It's heavily involved in the middle, and then upon exit, it's also a part of it. So to do it right and to do it right from the start when you're an emerging brand is key. So one of the things that we're going to be doing is answering questions that come into the show. They can be emailed directly to me at guy@guycoffey.com. That's GUI@GUICOFFEY.com. And so if you have any questions, just email, and then we'll keep your name out of it, but we will answer your question from one of the best franchise attorneys in the country / world, because Kevin also does work internationally. So maybe talk about that a little bit in one of the episodes too, if you're interested in international. But today, just wanted to give you a chance to get to know Kevin so that you're interested. And we're going to cover everything involved in franchising that's of interest to emerging brands. So Kevin, one of the things that we want to get right from the start is the FDDs and the franchise agreements. So maybe just a high level little blurb on that would help kick us off.
Sure. In the United States, franchising is regulated both at the state and federal level. And to comply with the federal rule, some people refer to it as the FTC rule, you have to have a disclosure document, a big fat franchise disclosure document. The document has to be written in a way that complies with the rules that are set out in the Federal Register. And it covers basically 23 distinct topics, all of which are very important for prospective franchisees to understand as they think about making an investment in your brand. The document also must be provided to a franchisee in advance of franchise sale. As a general rule, it's 14 calendar days before you can ask a franchisee to sign a binding agreement or take any form of payment. And then to add some interest to this, there are a number of states that require that the document be registered with those states before offering franchises in those states. We can get into the details about registration at a later time, but the bottom line here and what's really important is if you're looking at franchising or you're just beginning to franchise, make sure you're working with a lawyer and a legal team that fully understand the rules, because it's very easy to get tripped up and make a mistake. So for example, if you would like for some reason to require a prospect to sign a non-disclosure agreement, you can't do that because that's a binding document until you have provided the disclosure document to that person and let that 14 calendar day period run. If you would like, for example, to try and get some kind of a territory reservation fee, you can't do that until you've let that 14 calendar day period run. So there are lots of ways that franchising is different than other kinds of businesses. The rules around what you can talk about with people, the rules around what you can have them sign, and the money you can have them pay are all very much controlled by this regulatory scheme at the federal and the state level. And for emerging brands, it's very easy to make a mistake if you're not getting the right legal advice.
That's a great overview. And as we said, how you begin this is super, super important. And even if things do need to change because FDDs get updated every year, maybe you have something in there that you don't want in there the next year. It's not too late because they change every year. And so it's really important to make those updates. And if you're going down the wrong path, to get on the right path as soon as possible, right?
Absolutely. And the other thing that I would really caution people looking at franchising about is that there are three elements in a contract that make an agreement a franchise agreement. And the reality is simply by changing the name of the contract doesn't mean it's not a franchise. So if you are in the business where you allow somebody to sell goods or services using your name, and you're either going to provide significant marketing assistance or provide or require significant control over the way the business is operated, and you charge that person a fee for the right to get into the contract, you're a franchise. You can call it a license agreement. You can call it a distributor agreement. You can call it any other kind of a term. That doesn't mean that you get away from having to comply with franchise rules. Don't think you can find a lawyer who's going to say, let's call it something different and avoid all of the legalities associated with being in the franchise business.
And wouldn't it be true to say, you have more experience in this than I do, but a lot of times that recommendation is like, well, let's not go through the expense of a franchise right now. Let's just do a licensing. But they're mixing up those terms. And someone that's actually thinks they're licensing could actually be offering a franchise. And to be honest, a lot of people won't know, like, what's the difference? Who's going to catch me? Later on, I'll formalize this and get it right.
What is the downside of that?
Well, I think first of all, if you have a contract with those three elements and you call it a license agreement and you fail to prepare a disclosure document and get it registered in required states, you violated both state and federal franchise laws. How does this ever become an issue? It's when you get into dispute with that licensee, who then goes out and hires a lawyer who says, oh my gosh, I think you were sold a hidden franchise. There are significant risks associated to the person who's running the franchise company or involved in franchise sales that can include personal liability. So you can't merely hide behind the form of an entity that you created to be the licensor and say, sue that entity, don't sue me. A lot of these laws will allow for you to be sued personally. And a lot of these laws will offer sold franchises without disclosure the opportunity to get rescission. And rescission means you go back to where you were the day before you signed the contract. And if you are licensing, say, an investment in a submarine sandwich shop, the licensor who sold the hidden franchise could be obligated to pay back that licensee for all the money invested and all the money that was lost. And that could be a personal obligation, not something, again, you can put on the back of the franchise entity. So there are real reasons to pay close attention to this. But I think lawyers who suggest that you license are not doing it as a way to avoid the rules or to be malicious. It's that they just don't understand the difference between licensing and franchising. So again, step number one, find counsel with lots and lots of experience in the space that can guide you along.
And of course, we know of one right here, Kevin
Thank
and
you.
his group at Akerman. But would you say, like, if they are looking to get good counsel, we obviously have used you and your team for years and believe in it, and it's worked out really well, and you're a leader in the industry. But if someone is going down a different path, at least a general filter at the start is to look at firms that are associated with the IFA, wouldn't you say?
Yeah, that's a good starting point. And the reality is you can probably go to your local state bar and ask for people that are at least identify as having some expertise in the space.
Mm-hmm.
I always believe that when you're looking at hiring a lawyer for whatever, you should probably ask for references, especially in this area, to make sure that the lawyer has the experience necessary to guide you along the way. I also think that there is a reluctance at times to pay for the cost associated with the preparation of the legal documents, which is not inconsequential. But that goes to a much bigger issue, which is if you're going to launch a franchise system or you're building a franchise system, you've got to make a significant investment in what it takes to set that up. You are not going to be able to sell your way into profitability or viability because you short form your franchise documents. You get some person who doesn't charge much and you put together like a bare bones FDD and franchise agreement. What you're really doing is buying problems down the line. And I will also tell people, and Guy, you know this better than me, an emerging brand doesn't come out of the gate very often and sell a dozen or 100 franchise units in that first year. So the fact that that $50,000 fee sounds like a really good number or whatever you're charging, you're going to have expenses over and above what you're able to collect in selling franchises in probably the first 5 years of operations. So don't go into a business like this and be completely undercapitalized, because franchising isn't going to get you where you need to go, and you're going to leave a lot of damage along.
Yeah, that's so true. This is the foundation of the franchise business. It's a legal structure and a business model that's based on these agreements. So if you are trying to shortcut that, it doesn't bode well for all the other things that you're going to shortcut. This is step one. Don't start shortcutting at step one. And if your business, your brand is good enough to franchise and can do well, it's going to be attracting, whether you have the capital or if you need to raise capital in order to do this. The money is generally not the problem if you have a really good concept. You can figure it out, and then you can do things the right way right from the start. Because even emerging brands, like the short runway on them from a franchisor perspective, from my perspective as a franchisor, it's like 10 years. I mean, that's from start to exit if you want to. And if you don't want to, you can go longer. I mean, if you're thinking about starting a franchise brand to exit it and sell it to PE, like figure a decade, right? Isn't that what you normally see? Yeah.
Easily. I think we just closed a deal last week for a client that's probably been in the business 8 or 9 years, and it's their first exit. But yeah, I would definitely think you would need to plan on a decade. Mm-hmm. Some brands get really lucky and get there a little bit faster, but there's a lot of effort that goes into this. And this is not something for the faint of heart. This is not something that you can phone in. You are asking people that you don't know to invest in you and your concept by putting their money up to become the operators in their territories. That is a huge responsibility. And I think people don't take that seriously enough sometimes, because if the brand fails, and believe me, many more emerging brands don't make it than do make it, not only do you as the founder lose your money, but all these people that you brought in are going to lose their money as well. And there's just a lot of carnage left along the way.
Yeah. Yeah. Been through it, and, on the good side, and I've seen the challenging sides as well. So you do not, you're speaking the truth there from real world experience, a number of years for you and a number of years for me. So I know that we're going to wrap it up here, but one of the things that we're going to cover on one of our next episodes is the challenges of having things in your legal documents that are good for the long-term health of the system and everybody involved in it, versus things that some people might want to have changed to make it easier to market the business or to sell the business. So there's the tug of war there. And for emerging brands, they can easily get persuaded to do things that are going to make sales and marketing of the system easier. And we're of the mind that that's not the way to go. And we're going to cover that in our next episode. But Kevin, thanks so much for your time today. We really appreciate you, and hoping everybody gets a lot out of this, and looking forward to doing this series with you.
It was an absolute pleasure. Look forward to it, doing it again.
All right. Talk soon.
Thanks.
That wraps up today's episode of the Franchise Scale Up Show. If this gave you a strategy you can put into play, please share it with one founder who needs the help. You might save them months of pain. If you're ready to go deeper, whether it's building your support infrastructure, accelerating territory sales, or preparing for private equity, go to guycoffey.com. That's GUYCOFFEY, and book a free franchise growth strategy call. I only partner with founders who are committed to scaling without losing control. If that's you, I'd love to connect. Until next time, protect your vision, move fast, and scale smart. I'm Guy Coffey. Talk soon.